Good evening, everyone. Welcome to our final voting session for our community safety and policing reform package. So tonight we are working off of Amendment 248078/1. What I want to do is give members some time to read over the document before you, then we'll come back and discuss and vote. So just take a moment to yourself, reread what you have before you, and then we'll reconvene in a few minutes. All right, excellent. All right, now that everyone's had a moment to review the language once more, entertain motions to, is there a motion on the floor? Yeah, Senator Carter. We're going to, yes, adopted, then we can ask questions, but go ahead. Yes, Senator Carter.
Thank you, Mr. Chair. I'd just like to make a motion that we adopt the amendment
Is it seconded?
248078/1.
So there's been a motion.
Mr. Chairman, I second Senator Carter's motion.
Excellent, thank you. So you've got a motion, it's been seconded. Open for discussion. Senator Sidnor.
Thank you, Mr. Chair. The other night, I made a comment just talking about the use of force. And I'd like to thank everyone for doing the work that you all did. It is a lot of good things that I see that are in this bill. However, I still have some concerns about Section 10-801 under line 28 and the definition of excessive force, and in 10-802A, the use of the adjective intentionally being used before use of excessive force. There was an article that I read during the break that was in the Regulatory Review entitled Preventing Police Use of Excessive Force. And in this article, it talks a bit about where the country has been since Graham versus Connor was decided back in 1989, and other law review articles about what we might want to do with the police use of excessive force. And if I could, I'd just like to read just two paragraphs from this particular article, just so that you all understand where I'm coming from. It states that experts often frame police use of force as a continuum of escalating actions that officers take. But according to a 1989 unanimous U.S. Supreme Court decision in Graham versus Connor, all use of force by the police is governed by the Fourth Amendment's objective reasonableness standard. This standard focuses on the reasonableness of the officer's split-second judgment to use force. The courts will deem a police officer's judgment to be reasonable and therefore not excessive when a reasonable police officer on the scene would have judged the force necessary. Necessary means that the officer believed that the suspect posed a threat of serious physical harm either to the officer or to others, which could not be managed without force. The courts apply the standard of excessive force in such a demanding fashion that it makes it difficult to convict police officers who kill unarmed civilians. prosecutors must show that a reasonable officer on the scene facing the same split-second decision to use force would not have believed force was necessary. Although about 1,000 people die each year in their encounters with police, one expert found that since 2005, only 110 law enforcement officers nationwide have been charged with murder or manslaughter in an on-duty shooting. Those prosecutions resulted in a mere 42 convictions, although 18 cases are still pending. This article is written in June 13, 2020, just to give context. So the last paragraph that I'd like to read states, America needs a shift in perspective around the prosecution of police officers for excessive or unjustified use of deadly force, argues Jelani Jefferson Exum of the University of Detroit Mercy School of Law. In an article published in the Cleveland State Law Review, Exum claims that the current reasonableness standards inappropriately concentrates on the officer's perception of the dangerousness of the victim against whom the officer uses force. Instead, Exum argues the standard should consider the effects of racial bias, specifically that Americans over-attribute criminal activity to blacks, to determine whether the perception of dangerousness was reasonable. In addition, the prosecution of police use of excessive force should also incorporate an examination of the reasonableness of the officer's conduct prior to the use of force, he argues. This standard that we're adopting under B states that excessive force means force that an objectively reasonable law enforcement officer would conclude exceeds what is necessary to gain compliance, control a situation, or protect a law enforcement officer or others from harm under totality of circumstances. Yesterday when my good friend, the Senator West, made his amendment, I thought, and I totally agreed with what he said. Once we put in this language surrounding an objectively reasonable law enforcement officer and what they would conclude, to me, we just reverted back to why we're here. And to me, that's really an extremely large weakness in this bill. And then when you look at 10802, and we talk about a law enforcement officer may not intentionally use excessive force. I mean, if an officer is beating your tail, he intends it. I don't know how this protects me. Thank you.
Thank you, Senator Sidnor, for your passionate words, and it underscores the importance of our work here, and the work that we've been doing for the last several months, and the work that we will most certainly continue. And I appreciate your contribution, so thank you very much for saying that. All right. Further discussion? Is there a motion? Yes.
I have a question on section 3-212.
Actually, Senator Hellman, can we adopt these amendments first, then we'll discuss them, since we can just, is that okay? All right. Is everyone okay with adopting the amendments? All right. Amendments adopted. Thank you.
Section 3-212, section B. Subject to the hearing provisions of subsection B of this section, the commission may suspend or revoke the certification of a police officer if the police officer, et cetera, et cetera, et cetera. Why is that a may and not a shall? The decertification, that is a new part. There's no page number.
Hind.
The
Two after
page
eight.
after 8 of 11. it's the next page that's facing you. B.
What's-
It is B, subject to the hearing provisions of subsection B of this section, the commission may suspend or revoke the certification if the police officer, and then outlines a whole thing, a litany of things that the police officer has failed to do. I'm wondering why that is a may and not a shall. And then if somebody, can someone explain that?
Sure, yeah, I mean, there still has to be a determination, so once that investigation's happened, then a decision is made and rendered, and if there's a finding that they did fail to meet one of these standards or commit one of these acts, then that person will be decertified.
The way I read it is that they violate, they knowingly fail to, they misuse. So I'm wondering why there's discretion there, if they've already checked off those boxes of
Because it's like, I guess the analogy that everyone's been using is bar counsel for lawyers. So if there's an allegation made, then it's kind of like there's an actual like hearing for this, and then there's an adjudication. Where if it's found that that person has failed to adhere to any of these standards, then that person is going to be decertified and can never be a law enforcement officer anywhere in Maryland.
And how does this parallel the disciplinary process that they would go through under the other bill that we have?
It's actually, it works in parallel.
Brand new too.
It's a works in parallel. So you could be theoretically subject to criminal penalties, administrative penalties, and then also decertification. So it adds another layer of accountability and another layer of being able to be penalized and decertified. So, and all can move at the same time. Generally, criminal moves first.
Okay, I'm still wondering, I still don't really understand why that's a may and not a shall. If they've already failed to do X, Y, Z.
That gets determined at that hearing.
I'd also like to ask about how it is that page 6 of 11, section 10802, a law enforcement may, and I guess this goes to my colleague from Baltimore County's comments about a law enforcement officer may not intentionally use excessive force, kind of how the intentionality got in there and why.
So for excessive force, the way we've built this is if someone uses excessive force, they're subject to criminal penalties, they're subject to decertification, and so then there's this heightened, if it's intentional, then there's heightened penalty, right? So there's actually, so if it's intentional, they're subject to 10, I think the penalty is 10 years, up to 10 years in prison, and so there's a difference. So if there's excessive force, you get automatic decertification, automatic. Mm-hmm. So you can never be a law enforcement officer in Maryland, right? If you're convicted of that?
It's not automatic.
For a conviction of, if it's intentional. A conviction of intentional excessive force, it's 10. It can result in decertification.
I think in answer to your question, Senator, so excessive force, we tend to think of the most egregious cases that we see on TV of somebody taking an individual who's handcuffed and on their back and totally immobilized, and then an officer strikes them or puts their knee on their neck to strangle them. These are really egregious cases, which would certainly result in the officer no longer being a police officer. But intentional force can be something far less. And it can be not even intended. You can exert excessive force unintentionally. So where you get this discretion on decertifying people really comes at those much lower levels where it's a new officer. She was the adrenaline was flowing. She's got a good record. She's done everything right. And now we have this fairly low level. Do you just say, hey, look, no second chance for you, go find a new career, or do you give them the chance to say, let's watch this young woman. Maybe she's going to be the freaking most awesome police officer in the world, and she screwed up this time. So you get some discretion there, but clearly for the person on these nationally prominent cases, they're gone. And so there has to be that level of discretion in the entire process, right? And that's essential. So, and then, okay, so that now you have, on the use of force, you're holding somebody criminally liable. So in order to prosecute somebody and give them 10 years in jail, you wouldn't give somebody 10 years in jail if they're in a fight and now it's determined, hey, in that fight, you really technically did not do that right. Although you didn't intend to do it, you did use excessive force. So if it's not intentional, we can demote you, fire you, ban you from being a police officer, sue you, but we're only going to put you in jail if you intended to, if you, in the egregious case where you intended to do it. So the cases that we, again, talking about on TV, I put my foot on the person's neck when they're immobilized. I shot the guy in the back as he's running away in a jogging suit with no apparent weapon anyway. I mean, those egregious cases where it's clearly an intentional.
Somebody to a pulp. That's somehow not intentional?
Well, I think beating somebody to a pulp who is disarmed. I mean, it's possible that if an officer gets into a fight with somebody and that person's fighting back aggressively, I guess somebody could end up severely injured if they're trying to beat an officer to a pulp. But yeah, certainly if the person, if the force is intentionally excessive force.
I guess I don't
Okay.
really see the line between excessive
Thank
force
you.
and intentional excessive force. I'm struggling
Got
with
it.
that
All
one.
right. Got it. Thank you very much. Senator Huff.
I just wanted to speak on the actual amendments, and this has been a long process. And I was very happy today I could sit down with my friend, and Jill is my friend. We've been friends for many years. As you've seen, though, like friends, sometimes you argue and disagree. And there were disagreements on this, and there's things in this package that I wasn't totally comfortable with, and things that she wasn't comfortable with. But overall, just in objectively looking at this and taking into account what Charles and others have said, I have moved, and this package has moved even from where we were, even last night. And I just think we would be, we're not talking about really how groundbreaking and how much further this moves things. It's now in Maryland going to be a crime for police officers to fail to intervene, a failure to report. There's a new crime of excessive force. It's a brand new criminal penalty. We undid last night, and we went back and made it a criminal penalty for failure to render aid. And it's a brand new power of the Maryland Police Training Commission to decertify. They did not have that before. It was all the locals before. So now the Maryland Police Training Commission can decertify when there's failures and misuses. So this is a huge step forward for law enforcement accountability. This is, quite frankly, I think, in the beginning of the process, much further than I would have thought I would have been comfortable to go, but that's how all compromises are made. And so I just want to say, I want to move forward. I want to make a favorable motion on this. I'm very proud to work on this with my friend Jill. I think this is a positive step forward. So I make a favorable motion on the bill.
So there's been a motion for favorable. Is there a second? Second. Senator Carter seconds. Roll call. Also add that here. Just so everyone knows, will also be an amendment for a title change so it conforms to the rest of the titles in the package, and then to allow for further technical, stylistic, and conforming changes. So motion for favorable with amendments has been seconded.
Vice Chair Wadstraker,
Yes.
Senator Lee,
Yes.
Senator Casserly,
Yes.
Senator Hellman,
Yes.
Senator West,
Yes.
Senator Sidnor,
Pass.
Senator Jackson,
Yes.
Senator Bailey,
No.
Senator Carter,
Yes.
Senator Huff,
Yes.
Senator Sidnor,
No.
Chairman Smith.
Yes. All right, passes. Just before we move on to the next matter at hand, I just want to say thank you all very much for working through this. This has been extremely difficult. This has been the most difficult problem set I think any of us have worked on since we've been in the General Assembly. It's charged with emotion. We are charged with also not only sifting through the history and the vestiges of this country and policing and community relations, but also the minutia and the detail of the law. And I think we've done a responsible, serviceable job for the citizens of Maryland. Obviously, our work is not yet done, but I'm tremendously proud of the package that we put forward. This is by far the most comprehensive reform with regard to policing in Maryland that we've seen in over 40 years. And something that I think we can all be very proud of. Again, I qualify that by saying that our work is obviously not yet done, but this is something that we can be proud of. And I just thank you all for the work that you've put into this. Okay, now I'll turn over, and we have one more matter to attend to. We have an amendment for Senate Bill 627. If you get Senator Kessler.
I'd like to propose an amendment to Senate Bill 627, page 6. And it would be at 3102A2, strike any, and insert Roman numeral 1, except as provided in subparagraph 2 of this subparagraph. And then subparagraph 2, Roman numeral 2 would provide a local governing body may enact a local law governing the investigation and interrogation, polygraphing, and drug and alcohol testing of a law enforcement officer by a law enforcement agency that does not conflict with the subject and material of the subtitle. Paragraph 3, a law enforcement agency or the agency's superior governing authority and a collective bargaining unit may not enter into an agreement that relates to paragraph I, discipline of law enforcement officers. Paragraph II, the investigation, interrogation, polygraphing, or drug and alcohol testing of a law enforcement officer by a law enforcement agency in association with a disciplinary proceeding. Paragraph B, the procedures established by this subtitle are the exclusive methods for disciplining a law enforcement officer. The end of the amendment.
Excellent, thank you. So first I'll make the motion to reconsider the bill so that it can be amended. Is everyone okay with that? Is there a second?
Second.
Second. Is everyone okay with that? Great. So the motion has been before you. I will make a motion for favorable. Is there a second for that to adopt?
Second.
Second. Is everyone okay? Excellent. Great. Now the bill is before you again as amended. Motion is for favorable. With amendment? Second. Is everyone okay? Yeah. Repeat the vote as it was before. Keep the vote the same as it was before. Excellent. Okay. Thank you all very much. And with that, that'll conclude our voting session for tonight. Again, thank you all very much, and I appreciate the work. There you go.